All right, Mr. Grable, are you ready to proceed with Mr. Sepulveda?
We are, Your Honor. Thank you.
Okay, this is file 23-21463-FC, People versus Ricardo Sepulveda. We are here today for sentencing in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Ms. Hoffman.
Thank you, Your Honor. Good morning. Benita Hoffman, Assistant Attorney General on behalf of the people. For the record, my bar number is P48738.
Good morning, Your Honor. Attorney Scott Grable, P53310, for Mr. Sepulveda. Myself and Mr. Sepulveda are here by Zoom, and we waive, obviously, appearing in person. Thank you, Your Honor.
All right, and sir, you are Ricardo Sepulveda, correct?
Yes, Your Honor.
Mr. Sepulveda, this is a sentencing in a felony case. As a result of that, you do have a right to be present in person here in the courtroom for the sentencing hearing. I would only continue by video conference if you are willing to waive your right to be here in person and continue by Zoom. Are you willing to do that at this point?
Yes, Your Honor. I'm willing to waive my in-person right to be at court.
Okay. Have you had an opportunity to read and review your pre-sentence report?
I have, Your Honor.
Have you had an opportunity to discuss that report with Mr. Grable?
Yes, we just a few minutes ago discussed it.
Are you satisfied with Mr. Grable and the advice that he's given you?
Yes, we went over a few things on the report that we feel needs to be edited or omitted.
Okay. Do you wish to explain or challenge the accuracy or the relevancy of any of the information that is in your pre-sentence report?
Yes, we definitely would challenge some of the information, the accuracy of the information in there. I would defer to Mr. Grable to explain it.
Okay, Mr. Grable.
I would, Your Honor. First of all, Your Honor, I just want to make sure we sent to your staff, and we're filing a hard copy with the clerk's office, a sentencing memorandum. We've also given it to Ms. Hoffman from the Attorney General's office. For the record, I just want to make sure the court is in possession of that. And we do have a hard copy coming by mail as well. And I think Ms. Hoffman should be in possession of that as well.
I do have a copy.
Go ahead, Ms. Hoffman.
Your Honor, I do have a copy of the sentencing memorandum that was filed by the defendant's attorney.
Okay, and I have received and reviewed that as well.
Okay. Your Honor, I'll go into the report. There's just a few changes, Your Honor. On page 1 on the body, it says count 1, homicide, murder, first to be conspiracy. Just for clarity, Your Honor, I think it might be important just to change that to count 2, because obviously count 1 of the first degree premeditated, as the court is aware, obviously Mr. Sepulveda was found not guilty. I just think it might add some clarity because it is incorrect. It was count 2, not count 1. Not a big deal, but I still think it should be accurate on that point, just so Department of Corrections doesn't get confused. That would be my first change.
Okay, Ms. Hoffman, do you have any issue with that?
I do not, Your Honor.
Okay, so that should be modified to reflect count 2 as the homicide conspiracy charge.
Okay. On page 3 of the report, Your Honor, it indicates, again, count 1, homicide, top of page 3 of the report. It indicates, the charge is correct, conspiracy, but again, it references count 1 again for the same reasons I've illustrated. That should be count 2 on page 3. Again, same reason.
Any issue there, Ms. Hoffman?
No, Your Honor.
And Your Honor, I'll probably reserve argument on it, but I'm going to ask on that paragraph on the top of page 3, I would indicate that, and again, I'll make the argument when the court is ready. It's outlined in my memorandum that Department of Corrections should be aware that Mr. Sepulveda is eligible for parole after the appropriate time period, but I could be more specific, or I can do it now based on the sentencing memorandum. I don't think there's any dispute, but we can come back to that later, Your Honor. I can make some other minor changes and proceed whatever the court's pleasure is.
Okay, so just, I'm sorry, going back to the labeling of the counts, it looks like they should probably will all need to be renumbered.
That would be correct. I apologize, Your Honor. Just
Make them-
sequentially to respect, right. I would agree, and I
make them-
apologize. That would be, I guess, instead of 2, 3, 4, 5, it should be obviously 3, 4, 5, and 6, or 2, 3, 4, 5, and 6 on those numbers sequentially.
Right.
You're correct, Your Honor. I apologize. They should be altered for the same reason, just for the housekeeping purpose to make it accurate.
Yeah, so he was convicted on counts 2 through 6 and found not guilty on count. I'll save the parole issue for I think later. I don't think that's an issue with the PSI as much as it is what the sentence should be. So
That's correct, Your Honor. For the record, too, and I won't go into it, I did get a chance to speak to probation. I don't know if he's here by Zoom, Mr. Stevens. He agrees with me on the parole issue, and he can illustrate that himself. So he's not opposing that change. But I'll deal with that momentarily if he's here. He's consulted with Jackie Wise, the Lenawee County prosecutor, but he can verify what I'm saying. He agrees with me that this is parole eligible, but I wanted to mention that as well, but I'll ducktail back to that at the appropriate time with the court's permission.
all right, did you have any other additions, corrections, or deletions in the pre-sentence report?
I do. On the evaluation and plan, Your Honor, at the top, again, it indicates count 2 homicide, murder, first degree. Again, for clarity, I think it should indicate conspiracy to commit homicide. I think it's a little confusing. It looks like it has the correct count number, count 2, but it just indicates homicide, murder, first degree. I think it should indicate conspiracy to commit homicide, first degree, premeditated. Again, I think that would add the appropriate clarity to it. Again, I don't think it changes any of the dynamics, but I think it would be more accurate.
All right, Ms. Hoffman, any issue with that correction?
No.
Okay, so we will make that correction as well.
On page 2, Your Honor, under description of the offense, the paragraph that starts on 12098, Laura Lozana's former boyfriend, Thomas, and then it goes on. My understanding, obviously, I think that is in one of the incident reports that mentions that statement, but I understand, obviously, the court's aware, or maybe I have to refresh their memory. Thomas did not testify at trial. I think he was a subpoenaed witness, but I think they could not locate him. So for that reason, although I think there was some testimony that was outlined in the incident report, the fact that he was a no-show for trial, I would ask that whole paragraph and represented to Thomas should be deleted. But again, there was an incident report that I think mentioned that as a summary. But again, I think he avoided service. I think the court, and Ms. Hoffman will make sure I'm saying this accurately, I think there was a bench warrant issue, but maybe I'm confusing that with a different witness. If I am, I'm going to ask her to correct me because I don't want to mislead the court if I'm wrong.
All right.
So
Go ahead.
if I could respond, Your Honor, with respect to the missing witness, that the bench warrant was issued for, that witness was Billy Morgan, or William Morgan, which is his legal name. With respect to the comment made by Tommy Thomas, there were statements that were presented during the trial regarding Tommy Thomas. I think the correct way to handle this, if there is an objection, is that although Mr. Thomas did not testify at trial, an incident report says that he said this.
I would agree with Ms. Hoffman that I don't think simply the fact that he didn't testify at trial means that it can't be in the pre-sentence investigation report, because that report can include things other than the trial record. And so I think that the way that Ms. Hoffman has couched that phrasing would be appropriate, to simply indicate that although he did not testify at trial, there is an incident report which says the following. So I would make that correction.
Very good, Your Honor. One thing too, and I know we're going to address it, same page right under recommendation narrative, it indicates on count 2, the defendant served life without the possibility of parole. I just wanted to highlight it to the court's attention that obviously I'm going to object to that, but the court wants, if the court makes a ruling that may alter that, I'm going to ask they change that and just to highlight it to the court for later analysis once we're done going through these changes. On the top of page 2, I just didn't want to forget, just to make aware that the court may change that or may not, but I'm saying I want it part of the analysis of changing that, where it says it's defendant served life without the possibility of parole. That should be addressed when the court does address it. I just didn't want to forget that because obviously
Okay.
thank you, Your Honor. On the same page on 1/16/2002, it says Brahim Dahar, and then it goes on. This may be small. I think Mr. Dahar's testimony indicated during his then that they said there was some statement. He stayed in the summer of '99 while at Laura Lozano's house. Again, this may be quibbling, but I think he testified during trial they were at his house. Again, I don't think it changes anything dramatic, but to be accurate, I think he indicated it was his house. Again, I don't think it changes the dynamic, but factually, I think that's what the trial record indicated under oath.
Ms. Hoffman?
Could you give that to me again, please?
Yeah, I'll clean it up. I think the statement indicates that there was some discussion about this murder. I think they said the meeting took place at Laura Lozano's house. I think Mr. Dihar indicated the meeting took place at his house. I agree that may not be salient to change anything, but I think that's what his trial testimony said. I wanted to be accurate. I don't think it's going to change the nefarious nature of the conversation, but it's just for accuracy. I think it was a trial testimony.
So the issue is that the PSI says that the conversation occurred at Laura Lozano's house, and Mr. Grable says that the testimony was that the conversation occurred at Mr. Dahar's house.
That's I understand that's not an earth-shaking fact from a relevant standpoint, but Mr. Sepulveda brought that to my attention. I just didn't want to ignore it. Again, I don't think it's going to change the context of anything other than where the meeting.
Oh, okay. Ms. Hoffman, do you have any input on that issue?
Sure. First, the conversation regarding the plan to commit the murder began in Ohio and continued to Laura Lozano's house, as did
Okay,
the plan.
I'm sorry to interrupt, but you're not talking about the same conversation. This is a conversation that Mr. Dahar testified about, where Mr. Sepulveda told him that this had happened, not planning.
Oh, so I think that he actually testified that they were at Laura Lozano's home when he admitted he had gone to Laura Lozano's home and they were in the basement at the home and they were smoking marijuana. I understand the confusion because the incident report says that it happened at Mr. Dahar's house, but I thought the testimony at trial was that it was at Ms. Lozano's house. I think it's either. I think the best way to put it is that it either occurred at Laura Lozano's or it occurred at Brahim Dahar's.
All right, I don't have a recollection of what the testimony was on that point, and I don't think it's a relevant point to anything that would have an impact on what his sentence would be or what would happen in the future regarding his sentence. So I would just delete the phrase "while at Laura Lozano's house" and just leave it that there was a conversation.
Fair enough, Your Honor. The last sentence in that paragraph indicates he indicated they decapitated him, excuse me. Brahim Dahar indicated that Michael and Ricardo had told him about the murder separately while they were in prison. For the record, again, small issue. Mr. Dahar and Mr. Sepulveda never served in prison together at the same facility, so I don't know if there were any reports indicated that they were not in prison together at the same time. Again, not a big issue, but Mr. Sepulveda brought it to my attention, so I'm bringing it to the court's attention. I don't think it's accurate.
Hey, if I could, Your Honor, it was Yusuf Dahar that served with Mr. Sepulveda in prison, not Brahim. Yusuf
right,
was
so-
Fahim's brother. I'm sorry, Your Honor.
And I'm almost finished, Your Honor, after this.
I apologize, my memory's failing me. Yusuf Dahar did not testify, right?
Yes,
Yes, Your Honor.
I
That's
believe he's deceased.
I'm sorry.
I believe he's deceased.
Yeah, yeah.
Yes.
Okay, so then I would just strike and Ricardo from that statement.
Thank you, Your Honor. With the court's permission, I'll move along quickly to wrap this up. On 42005, there's a paragraph about a call that referenced, I think, a 911 call, which there is an incident report that indicates that Laura Lozano testified, obviously, at trial, and I think it would be inconsistent with what was in the incident report. I think there was some impeachment attempt, but she never acknowledged that. I think, or it was Misty Reynolds who testified. Pardon me, Your Honor. I apologize. I don't think she confirmed she made the 911 call or anything that would indicate the context of that paragraph. So I'm going to ask that paragraph be deleted because although there was an incident report, obviously, I don't think she was impeached at trial. She denied having memory or her memory wasn't refreshed. So I'm just going to ask the court to delete that whole paragraph in reference to this 911 call.
Your Honor, it was Kathy Furl that made the 911 call.
No, it wasn't. It was Misty Reynolds.
Okay, Rick, don't interrupt. It's let the judge rule on it, please. Obviously, go ahead.
If I may interrupt, if you look at the incident report, there were a couple of calls to 911.
Well, this says Misty Reynolds, obviously, in the statement. So, and whatever the court rules is fine. I just wanted to bring, obviously, it sounds like Ms. Hoffman is not saying it was Misty Reynolds, or that's what the PSI says.
All right, there does seem to be at least some error in that paragraph, and I think, again, it only would have tangential relevance.
I agree.
I'm just going to strike the entire paragraph and leave that paragraph out.
Thank you. I'll try to wrap this up. On page 3, Your Honor, third paragraph down that starts on 12/2/16, there's mention of a family wake. And I remember the testimony at trial. They heard Michael state that he witnessed Ricardo kill and dismember a man. I think the testimony at trial from Michael was, or I think there was actually another witness, not from Michael. And the name escapes me, but I think the testimony was your words are words to the effect you're going to go down for murder, MF. I'm not going to say what the court knows what the word MF is. And then I think they said Mr. Sepulveda was silent and didn't respond. I think that's probably more of an accurate rendition of what the testimony was at trial than this statement that was contained in the report. So I don't think that characterization in the report that I referenced is consistent with what was offered at trial by one of the witnesses at the wake. That's it.
I agree with Mr. Grable, Your Honor.
Okay. So that paragraph should end of that paragraph should read, they heard Michael state that Ricardo was going down for murder, which would be consistent with the testimony at trial.
Thank you, Your Honor. And one more point in the, I guess, on page 3 in the body, and I'm going to skip down, I don't know how many lines toward not the last paragraph, but the body of the polygraph where it's Toledo, Ohio area, down about 8 or 9 lines down. It starts at that point, Ricardo began to stomp the victim's head with his foot until he was deceased. I'm not sure, obviously, the client was acquitted of the first-degree premeditated murder. I don't know if it makes, at that point, he began to stomp the victim's head with his foot until he was deceased. I'm not sure. I would argue that the not guilty on the premeditated would make that statement, I guess, not supporting the record of the not guilty. So I would ask the court to delete at that point, etc. That one sentence. I would ask the court to delete that based on the not guilty of count 1.
Ms. Hoffman.
If we're going to change that statement at all, it should say that the defendant stomped his head until it was smashed in, while his brother hit the victim in the head with the butt of a pistol, and that he died thereafter.
I would defer to the court. I would just indicate the statement should be deleted, but I'll let the court rule on that. And that's my last change to the report, Your Honor.
All right, I believe that Ms. Hoffman's statement was an accurate reflection of what the testimony was at trial. I would preface the statement that that Michael testified that at that point. And I'm sorry, what was the remainder of?
So as the defendant was on on the victim's head, his brother Michael Sepulveda was pistol whipping him, and thereafter the victim died.
All right, again, with the preface that that is what Michael testified to at trial, that is what I would make that statement.
Thank you.
Thank you, Your Honor. And I
All right.
believe it's accurately scored as well, so I'm not challenging any of the scoring calculations on this as well, Your Honor.
All right, Mr. Grable, did the pre-sentence report disclose any prior convictions in which there exist any known constitutional defects?
I don't believe it did, Your Honor, other than the issue of that we're going to address on the parolability of count 2. Other than that, that issue I do believe would be a constitutional violation, but nothing besides that issue that we're going to address. I believe it's acceptable.
All right, and you indicated that you have no issue with the scoring of the guidelines. Is that correct?
I don't have an issue, Your Honor. I believe, and to the relevant offenses, I believe it's accurately scored with the guidelines that were in place at the time the offense was committed, based on the time established at trial. I concur with that. Yes.
Ms. Hoffman, did you have any issue with the guideline scoring?
I do not, Your Honor.
All right, and that was on the assault with intent to maim, 48 to 80 months.
I believe that's correct, Your Honor.
Yes.
Okay, so I have read your brief, Mr. Grable, with respect to the guideline scoring. I will give you a moment at this point if you want to say anything in addition to what you've submitted in writing.
I'll be brief, Your Honor. I'm not going to be circuitous. Obviously, I think the memorandum that we outlined illustrates that I think this is a absolutely black and white issue. I did want to add, Your Honor, I did bring this to probation, obviously Circuit Court probation's attention. I believe it was Mr. Stevens. I'm looking for his name in the report. I know it was signed by the supervisor. If I miscite who authored the report, he did contact me a couple days ago, and I don't know if he's in the Zoom meeting room. I'm hoping he is. So he'll confirm what I'm saying. He agreed with me that this is a parolable offense. He indicated that he consulted with Jackie Wise, who I understand is not the prosecutor in this case, of course. She is the Lenawee County prosecuting attorney. He will confirm that she agreed as well. This is a parolable offense. Obviously, the law in place, Your Honor, in 1997, based on the rationale and analysis in my brief, makes this a parolable offense that, in my opinion, should be reflected in the judgment of sentence. Obviously, the law changed on this, I believe, in 2014. Obviously, the court's aware of ex post facto that obviously the punishment that was applicable at the time in 97 would make this a parole eligible offense, and you can't apply retroactively the 2014 modification to the statute. So clearly, this is parolable. I think the case law is clear. I don't think the case, I think Ms. Hoffman gave me a case that was a 1986 case. It doesn't apply or change the rationale here. My position, in my opinion, is crystal clear and correct. I'm sure the court, knowing I know the court's, how the court handles these procedurally, I'm sure the court did a copious review of this. So I'll defer to the court, but I do believe everything in the report that indicates this is not parolable should be modified to parolable, and it should be included in the judgment of sentence. I believe it would be parolable after 15 years. Obviously, it still has to go through the parole board, but it is parolable, in my opinion. I think it's absolutely unequivocally clear based on the case law I cited in my memorandum, which I incorporate. Thank you.
Ms. Hoffman.
Your Honor, turning first to the issue of parolability, the statute does specify that the defendant is to be sentenced to life in prison. It does not say non-parolable life in prison. So I agree with him with opposing counsel regarding that particular issue. However, that does not automatically mean that Mr. Crawford is going to be eligible for parole or that he's going to receive a shot at parole in 15 years. Michigan Department of Corrections guidance on this says that the person can be considered, but at the time in 1997, the policy of the Michigan Department of Corrections was that life meant life. And part of the reason for that is because a first-degree homicide conviction or conspiracy to commit first-degree homicide, by simple logic, should carry a harsher penalty than a second-degree murder charge, which also carries life or any term of years. And so for that reason, I believe that the pre-sentence investigation report need not reflect that he's eligible for parole in 15 years, because once he gets inside the Department of Corrections, it is up to the Department of Corrections. There is federal case law on this issue in terms of whether or not being granted parole or being denied parole such that the person winds up serving life without parole is an ex post facto violation. And the Sixth Circuit, as well as the Michigan Supreme Court, have both concluded that it is not. If opposing counsel had served me his sentencing brief sooner, I could have gotten a response put together. I can find the cases for the court if the court would like that. One of them is People versus Neely, and then the other one is People versus Fernandez. And then the third case that I wanted to bring to the court's attention was the, hold on, I will find it. Give me 1 second. I had it open. The one is People versus William Edward Neely, and it is case number 165185, which was issued July 8th of 2024.
So
And
it's
then
not reported?
it is reported. All Michigan Supreme Court cases are reported,
Well,
Your Honor.
can I have the site?
I don't think it's been reduced to a site yet, Your Honor, because of the way they publish the volumes. But if you'll give me 1 moment. Yeah, I only have, Your Honor, I apologize. I only have the case number, which is number 165185, and it was issued July 8th of 2024 by the Michigan Supreme Court.
And I'm sorry, what were the other cases that you mentioned?
People versus Neely was one, and the other one was other one. Foster Bay versus Sampson. But it's an unpublished opinion, Your Honor.
So I guess, let me just see if I can understand clearly, Ms. Hoffman, do you agree or disagree that the court cannot sentence to life without parole?
I believe that that is correct. The court can sentence to life and make a recommendation that he not receive parole, but I don't think that the court can issue a sentence of life without parole. And the distinction is that if the court were to recommend no parole, that would be a recommendation that the Department of Corrections Parole Board would receive, and they have the authority to determine whether or not he's eligible for parole or will receive, I should say, whether or not he should receive parole at 15 years. So I'm asking the court to sentence him to life and to recommend that he not be granted parole.
I would object to that, Your Honor. I would let the parole board decide. I've never seen a court put in there that you're recommending against parole. I've never heard that in a judgment of sentence. Again, to be respectful, obviously, once I determined this became an issue, I served the sentencing memorandum. I have not reviewed the cases, obviously, that Ms. Hoffman made. I can agree with her. She needed additional time. I certainly wouldn't have posed an adjournment for the sentencing today so she could submit those citations. Obviously, Mr. Sepulveda is in jail. He's not going anywhere. But either way, Your Honor, I don't think any of those cases are going to stand for the proposition. And again, I haven't read them, but it doesn't sound like they stand for the proposition that the court can now function as the parole board. I'm recommending against parole. I don't think so. I don't think it's respectfully, I think the court has wide powers, but I don't believe the court should now put their hat on as the parole board to recommend against parole. I've never seen that in my life. I think it should indicate that he has the possibility of parole, and I think that's what the judgment of sentence should reflect, and let the parole board make the determination, not the circuit court. And I say that with respect to this court. I understand they have equitable powers and some plenary powers, but I don't think that language would all be appropriate in the judgment of sentence. I don't believe any case law or anything supports that. But obviously, I'll defer to the court, but I think I'm correct on that issue. Thank you.
Your Honor, if the court is inclined to follow Mr. Grable's analysis, then I would recommend that the court sentence the defendant to life in prison and not say anything about its eligibility for parole, and let the Department of Corrections follow its internal procedures and statutory authority when determining whether or not he's eligible for parole. Because there is a distinction between being eligible and being granted, and MDOC has had in the past a policy that did not allow parole for a first-degree homicide offense or for conspiracy to commit first-degree homicide. And it was upheld. it wasn't considered an ex post facto violation of the law for that to occur because the discretion to grant parole is completely within the discretion to grant or deny parole rests with the parole board, although the court can be consulted with respect to whether or not parole should be granted. That was the procedure back in 1997. So to simplify, I'm just asking that the court sentence him to life in prison and perhaps just not say anything at all about parole.
I think, I didn't mean to cut Ms. Hoffman off. Were you finished? I didn't want to cut off your thought.
As to the parole issue, yes.
Okay, that's fine. Judge, the only language I put in there in my memorandum, I think I think it speaks succinctly.
Mr. Grable, I apologize for interrupting, but I've read the memorandum and so the continued back and forth at this point, unless you have something new is not, is becoming cumulative. So.
Okay, fair enough. Your Honor. I think it should say is the life set that.
Okay, thank you, Mr. Grable. Thank you. I know what you think it should say.
All right, well, I won't say anything further. I think the court certainly is aware of the argument. Thank you, Your Honor.
What is clear to the court is that the law as it existed in 1997 is the law that the court has to apply in sentencing today. At that time, as Mr. Grable has pointed out in his memorandum, the law did not have a provision for sentencing a person to a life sentence without parole. And so the court does not have the power to sentence Mr. Sepulveda to a life sentence without parole. And that is how the court is going to operate today. I'm not going to get into what the policies of the Michigan Department of Corrections were in 1997 because it's not my job to make or apply those policies. It's the job of the Michigan Department of Corrections to apply those policies. So that's how I intend to treat this matter. Did you have other issues you needed to address, Mr. Gray?
No, Your Honor. I just want to make sure with the court's guidance, what areas of the pre-sentence investigation report that's modified to reflect the court's ruling. And I'll let the court put on the record what they want to change. I've noted a few places that I think would hopefully, and I'll let the court decide, should effectuate what the court just said.
To the extent that the report has any indication of the sentence being without parole, I would omit any such references.
And I think, obviously, I've highlighted the areas, Your Honor. I'm not going to repeat them as long as it's notated in the final version. I just want to make sure that doesn't add any. I think you were crystal clear. I just want to make sure the report doesn't confuse Department of Corrections because we may potentially be revisiting the issue in 15 years. And I think as long as the court makes the notations, I'm certainly satisfied with that, Your Honor. I think the ruling was, you made it clear. Other than that, Your Honor, I won't take up the court's time on this issue. I think it made its ruling.
All right, Ms. Hoffman, did you have any additions, corrections, or deletions? I don't believe I ever asked you that question.
No, Your Honor, I don't.
All right, before the court passes sentence, then, Mr. Grable, is there anything you want to say on behalf of Mr. Sepulveda?
Well, Your Honor, the court heard lengthy testimony. So as far as allocution, I'm simply going to ask the court, other than the modification for the parole, to follow the recommendation, Your Honor. I don't think there's much that can be said that isn't said in the pre-sentence report. So I'm just going to ask the court to follow the recommendation, Your Honor, obviously, other than the parole modification that the court has opined on. Other than that, Your Honor, I'm not going to say anything else. Thank you.
Mr. Sepulveda, is there anything that you would like to say on your own behalf before the court passes sentence?
No, Your Honor.
Your Honor, I'm sorry. Do we have a concession that there is a prior felony conviction for the purposes of the habitual offender supplement? It's referenced in the report. Opposing counsel didn't object to it, but I want to make sure that that's established.
I believe it's established, yes.
Thank you. I do wish to allocute if the court would allow.
Go ahead.
Thank you. Your Honor, this was a horribly gruesome crime that was related to drug trafficking in Southeast Michigan and Northwest Ohio. In all of the things that the court has to consider, one of the things that is significant is that this victim was kidnapped from Ohio and brought to Michigan, where he was brutally murdered and then dismembered. The defendant's conduct was clever, it was calculated, it was goal-oriented, it was plainly premeditated. He scattered the evidence along with his brother in a way that made it impossible for law enforcement to identify who the victim was, and which successfully kept his involvement in the crime hidden for several decades. The savagery of the crime is just beyond explanation. To imagine being kidnapped, hit over the head, stabbed, taken into a field, stomped out, hit with a pistol, and left for dead, and then to have them come back and say, oh no, that wasn't good enough, we have to go back, and then cut off his head and cut off both of his hands so that no one could identify him. And to make matters worse, they further desecrated the body by pouring some sort of a solvent, bleach, possibly Drano, over the victim's body so that no trace evidence could be found, so that no identification of this victim was possible. And here we are, several decades after the offense. We still don't know who the victim is. We don't know the true identity of the victim. Somewhere, whether they're good law-abiding people or not, there is a family that needs to know who this victim was so that they can know for sure what happened. And perhaps the worst part about the crime, in addition to the severity of it, the brutality of it, is the unlawful motive it served to achieve, and that is to avoid paying a drug debt to a cartel. I respectfully submit to the court that in addition to the sentence being imposed for the defendant for life in prison for the first offense, that the court should depart from the sentencing guidelines on the lesser offenses and sentence the defendant to 10 to 15 years on the minimum sentence. Because of the severity of the crime, because of the brutality with which the crime was committed, because it was organized, premeditated, related to cartel involvement, because it was beyond what was necessary to kill the person. The state firmly believes that the defendant should go to prison for the rest of his life. The state also firmly hopes that the Department of Corrections never allows Mr. Sepulveda to be granted parole and never allows Mr. Sepulveda to rejoin society. He's too dangerous. He's too dangerous, and his connections in the outside world in civilized society are connected to the uncivilized portions of society, those who resort to this kind of violence to continue to profit, to protect their profit margin from the trafficking of cocaine and fentanyl and heroin and marijuana. For all those reasons, we ask the court to sentence him to life in prison for the conspiracy to commit murder. And we also ask that the court depart from the sentencing guidelines for the objective and verifiable reasons that are not covered by the sentencing guidelines, and sentence him to 10 to 15 years on each of the lesser offenses. Thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offenses, your history, the principle of proportionality, the statutory penalty, the cost of confinement, the report and recommendation of the probation department, as well as what's been said on the record today. The criterion reasons for the sentence are the nature and gravity of the offense, the discipline appropriate to their commission, deterrence against repetition by you and by others, vindication for the law, and the protection of society. Mr. Sepulveda is 53 years old and has been convicted of conspiracy to commit homicide, first-degree murder, assault with intent to maim, 2 counts, and tampering with evidence, 2 counts. Court obviously sat through the trial and heard all of the testimony in this case. And I would agree with Ms. Hoffman that this was a particularly gruesome offense, the likes of which I certainly have never seen before in my time on the bench. And it resulted in the death of a person who is still unknown, at least to us. And somewhere in this world, there are people who have grieved the loss of a son or a brother or a husband or whatever relationships that this person has when he was murdered. It also occurred in the context of a drug dealing operation. And so there was, although not charged in this case, testimony of significant other criminal activity that was going on, which it appeared from the evidence to be primarily orchestrated by Mr. Sepulveda. In looking at the guideline scoring on the assault with intent to maim charge, the guidelines ended up at 48 to 80 months. I would note that the offense variables were scored at 115 in this case. And when we look at the severity levels as they go up, we're well beyond the top, the minimum score for the top level of the offense variables. And I think that speaks to, again, the gruesome nature of the crime and what occurred here. With respect to the conspiracy to commit homicide case, I've stated it already, but the law that applied in 1997 is the law that applies to this case. In 1997, the law had no provision for sentencing a person to life without possibility of parole. It simply said that a person guilty of this particular crime would be sentenced to life in prison. And so that will be the sentence of the court on count 1, that Mr. Sepulveda be sentenced to the Michigan Department of Corrections for life with credit for 878 days served. There is in that file, $130 crime victims' rights fee and $340 state cost. With respect to the remaining counts, the 2 counts of assault with intent to maim, which include a habitual offender, as well as the 2 counts of tampering with evidence. I do believe in this case that the guidelines do not adequately address the particular circumstances of Mr. Sepulveda, and they do not adequately address the circumstances of this crime, particularly the gruesome nature of not simply murdering a person, but in the context of doing that, also kidnapping that person, taking them across state lines to try to conceal, finish the job, essentially. Try to conceal the body, and then come back later and cut the head and the hands off of a person to conceal that person's identity so that they would never be known. And again, to this date, that identity is not known. I think that goes far beyond and is more heinous, more savage, more gruesome than even the vast majority of the murder cases that we have to deal with. And so I do think that a more proportionate sentence on those counts would be 10 to 15 years rather than what the guidelines would call for. And so that would be the sentence of the court with respect to counts 3, 4, 5, and 6. All would be 10 to 15 years with credit for 878 days served. Those sentences are all concurrent with each other. Mr. Sepulveda, you do have the ability to request an appeal of your sentence. We will send to you 3 copies of the notice of right to appellate review and request for appointment of attorney form. When you get those forms, you'll need to sign 1 copy and return that to the court. It just indicates that you received your copies of those forms. If you want to appeal your sentence, you would need to fill out the remaining portion of that form and mail it to the address listed in the form within 42 days. Do you understand that, sir?
Yes, Your Honor. I would ask the court in the meantime to recognize that I'm going to proceed pro se until such a time as I can fill those forms out. Following today's hearing, I mean.
All right. That is fine. If it's your wish to represent yourself at this point until you get those forms, that is your right.
Your Honor, could I also ask the court, I don't know if this is the proper time or not, to provide me with a copy of the trial transcripts and any of the evidence exhibits?
I think those might have been ordered, but I will check, and if they have not, we will enter an order for those to be prepared.
Thank you, Your Honor.
All right. With that, then you can let the officer that's with you know that you are done with court for today.
Oh, one last thing, Your Honor. We haven't you haven't talked about court costs or anything like that?
I think he did. I think the court indicated there was 133.40. Obviously, for the record, the client's indigent, Your Honor, but obviously the court's ruled on that, but I think I'm not going to address that other than these indigents.
Okay, so I guess just for, could you please repeat what my total costs are or whatever, Your Honor, just so I have a clear understanding?
The crime victims assessment is $130, and there's a state cost of $340.
And
where do I pay those to, or is there any possibility of getting?
I can advise you on that after.
Is there a possibility of getting any of those costs waived or reduced?
So I've waived all of the costs that can be waived and assessed the ones that I'm required to assess.
Okay, understood. Thank you, Your Honor.
All right. So if that's all, then you can let the officer that's with you know that you are finished with court.
All right.
Thank
Thank you,
you.
Your Honor. Thank you, Mr. Gravel.
I appreciate it. Thank you, Judge. Thank you, Ms.
Thank you,
Howell.
Your Honor.